Good morning, everyone. If you're just joining us, welcome aboard to our session of online law talks for this morning. I'm Lynn Haldane. I'm the Executive Director of the Victoria Law Foundation, and it's great to have you with us. If you're with us for the session with Tim Hutton from Youth Law on rights and responsibilities, welcome back. And if you weren't in that session but you'd like it, make sure you stay across our website and we can make sure you get the link. Now we're going to talk about courts and juries with a fantastic pair of people who have been deeply involved with these issues for a long time, Victoria, Jane Patrick and Paul Dorr. But before we get underway with that conversation, I'd like to take a moment to acknowledge the traditional custodians of country wherever you are joining us. Victoria Law Foundation is on Wurundjeri land, and so is Paul. Jane and I are both on Bunurong country, and of course they are both peoples of the Kulin Nation. Pay respect to their elders and to all the generations of Wurundjeri, Bunurong and other First Nations peoples, and acknowledge that the lands were never ceded. We recognise the impact of colonisation, its legacy of injustice, the marginalisation of Aboriginal and Torres Strait Islander peoples, and we believe that acknowledging the past is an essential step in building a better and more equitable future. The Victoria Law Foundation aims to break down the barriers to justice for all Victorians through our work in research, education and grants. We are genuinely committed to making a contribution to a better justice system for all of us, especially those vulnerable and most in need. A few quick housekeeping notes. You will be aware by now that your cameras and microphones are off as attendees. But fear not, the chat function and the Q&A function are both operable. Please just use the chat if you're having technical issues, and then we can see the issue quickly and resolve it for you. There will be time for the questions at the end, so please use the Q&A function, pop your questions in, or to give things a thumbs up if you've seen one that you'd like to hear the answer to as well. We are recording today and we will send you the link so that you can watch it again or send it on to other people. Today, we're going to hear about how judges, juries and courts work together. We'll also learn about what the internet has done to many aspects of the court process. And I think we'll also get to what the pandemic has done also. So we are delighted to have with us retired County Court Judge Jane Patrick and the Victorian Juries Commissioner, Paul Dorr. They are going to have a conversation about their different perspectives on courts and jury trials, and then we will come back together for a Q&A session at the end. Let me just give you a quick thumbnail sketch of Jane and Paul. You can see them on screen now. Jane was a County Court judge for 10 years. She specialised in crime, and before that she was a magistrate for 8 years. So she's seen some high volume turnover in courts. After studying law, Jane works as a legal studies teacher. So she is perfectly positioned to give you the lowdown on how courts and juries work for your purposes. Since coming to Melbourne from Montreal in Canada in 1994, Paul Dorr has been a very senior bureaucrat in the justice system. He's held senior operational and policy roles, first in the youth justice system and now with the Courts and Tribunals Service. And before he was the Juries Commissioner, which he became in March 2012, Paul was the Supreme Court's Chief Operating Officer. So he also knows his way around a court. Welcome both Jane and Paul. Look forward to your conversation and I'll come back again soon.
Thanks, Lynn.
Thank you, Lynn. And I think it's to me to start. Thank you, Paul. We're here talking to you about juries, courts, judges and internet and social media. I was appointed a County Court judge in 2008, and when I was appointed, I knew that I would be sitting in crime and that I would be in charge of juries. I knew a little bit about juries and about the history of juries. I knew that juries were usually 12 randomly selected impartial people who made a decision on the facts. Where did juries come from? Well, nobody seems terribly sure about all that. Some sources say they started in very olden times in Germany. Other people say they started in France. Everybody in the historical world seems to be agreed that when William the Conqueror came from France and conquered England in 1066, he brought a jury system of some type with him and implemented that in England. So we're now talking about in England, although the Anglo-Saxons who were living there already seem to have some way of having local people making decisions about whether someone had done something wrong. So in the 1100s in England, jurors by that time had to be free and property owners. So being free meant that they weren't serfs or slaves, and they had to be property owners. This, of course, meant they were all men and knights. So the sheriffs who were in charge of charging people with crimes would go out, and they would go out and find jurors, free and property owners, men, who knew about the case, either themselves from firsthand things they'd seen or from what they'd heard from around the neighbourhood, and who could give evidence to the justices about the case. So the justices would decide the case. So they had to know something about it, not impartial, not like what happens now. Up until 1219 in England, you could be tried in various ways. You could have a jury trial, or you could have trial by ordeal. You probably have heard of how witches were tried by ordeal on a ducking stool. If they were ducked into the water, and if they drowned, they were innocent, and if they survived, they were clearly a witch and they were guilty. So it's that sort of thing. There was also trial by battle, where you could go and fight the other person who was accusing you of something, and the winner was the winner, and declared, don't think they declared them innocent, but they were the winner. In 1219, the Catholic Church forbade trial by ordeal, and the Catholic Church, of course, was very important. So then they had to look for alternatives. There was still trial by battle, but then the jury system became very important. And gradually they changed the jury system and developed it. And by the late 1700s, much more like a modern jury system was implemented. There would be a ballot of a list of men selected from people who met the property qualifications. So you had to own a certain amount of property to be on the list, and then you would be balloted onto the jury. Now, when English colonists, English, Scottish and Irish, I suppose, but English and British colonists came to Australia and colonised Australia, they brought ideas about juries with them, but it took some time for the jury system to develop in Australia. By 1901, Section 80 of the Australian Constitution guaranteed a jury trial for indictable offences against any law of the Commonwealth. And I'll talk a bit more about indictable offences in a minute. The first jury trial in Victoria was in 1839, when Victoria was still under New South Wales law, so this was before Federation. A man was charged with stealing a pair of trousers with a shilling in the pocket. He was declared not guilty by reason of insanity by the jury, and that was the first jury trial in Victoria. Now, before I was a judge, I was a magistrate working in the magistrates court, so I knew the difference between summary and indictable crime. So all crimes are either summary or indictable. They're labelled that way. The difference is that the more serious crimes are indictable and the less serious crimes are summary in broad terms. Summary crimes can only be dealt with in the magistrates court. So in the magistrates court, we dealt with summary crimes, but we also dealt with some indictable crimes where the accused person consented to the magistrates court having jurisdiction. So if I give you an example of theft, theft is an indictable crime. The maximum penalty for theft is 10 years imprisonment. But obviously some thefts are really minor. You might steal lollies from a shop, or you might steal some lipstick from the chemist or something like that. That's a very minor thing. It doesn't need to go to the county court and be dealt with in the county court or by a jury. It's not a big deal in that sense. Other crimes are very significant of theft. You might be stealing hundreds of thousands of dollars. So where it's a more minor theft, if the accused person consents, then that can be dealt with in the magistrates court, and the magistrates court deals with heaps of minor thefts like that and other more minor indictable offences. You can still send someone to jail, but not for as long as you could if they went to the county court. So why do they need to consent? They need to consent because if you plead not guilty to an indictable crime, then you are entitled to have your matter dealt with, your contested hearing dealt with by a judge and jury in the county court or the Supreme Court, depending on the seriousness of the crime. If you're charged with a summary offence or charged in the magistrate court, you get charged on a charge sheet. If you get charged on indictment, that means the DPP makes a list of all the crimes you've committed in a formal document, and that is the indictment document. And then if you plead guilty, you get a jury. I plead not guilty, sorry. If you get guilty, you can go and be sentenced by the judge, but if you plead not guilty, then you get a trial, and then you only get sentenced if you're found guilty by the jury. Now, my first close encounter with a jury was when I was appointed as a county court judge. And I was a judge sitting for 10 years, as Lynn has said, only in crime. So I subsequently learned a lot more about juries. Now, there are occasionally juries in civil trials, but I only ever worked in crime, so I don't really know much about them. Paul Dorr, who's our Juries Commissioner, may know something more, but I'll stick to what I know, which is about criminal trials. Now, my first criminal trial as a judge, there I walked into court. Now, the person was charged was Mr. I can say his name, it's public, Mr. Pham was charged with obtaining property by deception. He pleaded guilty to some other charges, but he pleaded not guilty to that charge, which is an indictable offence. What happened was that his wife had gone overseas and he had tried to sell their house using a false power of attorney. He'd entered into a contract of sale. So I'd done some reading about the case, and I talked to other judges about what I was supposed to do when I went in and there was going to be a jury trial. I worked on my empanelment script. That's the thing that judges say to juries at the beginning of the trial. And I went into court, and therein was the courtroom. And there in the courtroom were the court staff, the Juries Commissioner staff, practitioners, the accused in the dock at the back of the court, and about 40 people who were the jury panel, out of whom 12 were to be selected as the jury. Now, the picture, thank you, that's being shared on screen is not a picture of that courtroom, which was in Melbourne. This is a picture of the county court at Bendigo. And the picture is taken from the dock. So that's where the accused sits at the back of the court. And you probably can't see because I look a bit too small, but that's me being the judge at the other end on the bench with my associate and tip staff. And to the right is the jury box, to the left is the witness box. So if you can imagine when I was in Bendigo, if I came into that court and there was a jury empanelment process, all of those seats, and there are more seats to the other sides, all of those seats would be full of people, about 40 usually, but sometimes more, waiting to see which of the 12 were going to be selected for jury, to be the jury in this trial. Thank you. The slide could go off now. Thank you. So those 12 people who were going to be selected would decide the facts of the case, and they would apply the law that I told them to the facts of the case. And by doing that, decide whether the person was guilty or not guilty of the offence charged. If the person was found guilty, then it would be up to me to sentence them. It was my job to make sure that the trial was fair and conducted in accordance with the law, and to direct the jury as to the relevant law that they needed to apply. It was a very big responsibility. What I didn't know anything much about at all was how those 40 people who were the jury panel came to be sitting in my courtroom waiting for jury selection process. How did they get there? The person who knows how they got there is Mr. Paul Dorr, who's the Juries Commissioner from Victoria. So, Paul, would you like to explain perhaps how they got there?
Gee, I hope I can. Thanks, Judge Patrick. I'm sitting there writing notes as you're talking because as you were studying law and sitting as a magistrate, I was a bartender in Montreal. Just wondering, the same questions that you had about juries. And so first things first, I have to say to you, Jane, that you would not have been the first judge who sat on the bench for the first time and said, where did those 40 people come from? And I can tell you, certainly you are not the last. Part of one of the things I really like about my role is that I contribute in a small way, but I'm part of the new judge induction program. So when a judge is appointed, it's all very secretive. It's a governor and council appointment. You would have known weeks, maybe months ahead that you were going to be a judge, whereas the rest of us learn every second Tuesday. Parliament announces that there's a new judge. So, and then we all scramble to welcome you. So one of the things that I really do enjoy about my role is that I've been the juries commissioner for 9 years, and that contributing to the induction. And I will say that more often than not, the newly appointed judge very, very sheepishly says, "I had no idea that that you existed, and that all this activity occurs to get that group of 40 people into your courtroom." So, I mean, the answer to the question is it's the Juries Act. I sleep with it under my pillow. The Juries Act establishes the role of the Juries Commissioner, and it provides the instructions, the legal instructions around how we select citizens from the jury, from the Victorian Electoral Commissioner's role, and how we summons them and assess their availability or their eligibility, and so on. So I'll speak a little bit about that shortly. Those 40 people, that panel is in the courtroom on day one of the trial. So that begins the jury trial. Now, Judge Patrick and others would have had a lot of what they call pre-trial argument before the trial starts. So, and that's where the judge case manages the trial and eyeballs lawyers and make sure that they know all the, what witnesses are coming and what evidence will be and all that. But that 10:30 in the morning when the trial starts is when those 40 people walk into the courtroom and the selection process begins. So they, in that courtroom, 40, judge, a few lawyers, an accused, are really just the tip of the iceberg of the jury selection process. So if you'll allow me, I'll describe just sort of how that works and how my office runs. I often think that Juries Victoria is just an island off the coast of courts. We're not essential to the trial by jury process. We're not essential to the trial. We're not a judge. We're not the judge. We're not the lawyers. We're not the jury itself. But we're sort of the infrastructure that allows that court process to happen. So we're very, very important up to the door of the courtroom, delivering those 40 people to a court to allow the judge to then do what judges, the very important, very weighty work that judges do. The purpose of the Juries Act is to provide for the operation and administration of a system of trial by jury that equitably spreads the obligation of jury service amongst the community and makes juries representative of that community. So back to Jane's description of the history of juries. Prior, when they were first, as you heard, when they were first established, you actually had to know something about the matter that was coming before the court. You weren't representative of your community. You were a man and you owned land. Whereas now the obligation is to randomly select people to ensure that you've got the community represented. I have to take an aside and tell you that I learned through some study I did over the last couple of years that in the province of Ontario, in Canada, they still select their prospective jurors from the Land Titles Act, not from the Electoral Roll or any other So you're very likely to get a less than representative jury if you have to own property. That rules out all the renters and anybody else. So just interesting. And I hadn't realized that until you had said that, Jane, that was the history of things. So back to me, or back to Juries Victoria. So the Juries Act creates the role of the Juries Commissioner. And look, I've got to be honest with you. While our legislative role is to allow for the operation of a system of trial by jury, a big part of our role is busting myths or trying to educate the community about the jury system. And I say busting myths because all of us, including me, our first understanding of a jury system was probably from American TV or American movies. And I often say to students that if your only understanding of the jury system is from American TV or American movies, you're probably not going to pass the SACs that are before you, or the legal studies curriculum, because it is remarkably different in Victoria and in Australia than American TV. And I would dare say, I think the American system is probably remarkably different than American TV. I mean, they will certainly sensationalize things to make it interesting. So I think there's just two very quick things I want to say about the distinction between American TV and the rest of the world. There's really two very big differences, and these are things that we need to explain to prospective jurors, citizens of Victoria, to ease their anxiety, because it is not uncommon for people to come to us summoned with the expectation that they will be on public display. So if you've watched anything Law and Order, or any of the show Bull, which is Bull, the panel members, those 40 people that are before Judge Patrick at the beginning of the trial, undergo almost an interrogation or at least an investigation into their personal circumstances, and the lawyers are allowed to assess their appropriateness for the jury trial based on information that they have to offer up, which is a lot different than in Victoria. The judge and the lawyers at the beginning of the trial know nothing about those 40 people, except that they have a panel number, and we might hear we will hear their occupation. So the 40 people are identified as number 22, public servant, not Paul Dorr, who lives at this address and makes this much money and voted for Ronald Reagan, type thing. Whereas there's a lot more information provided to the court. And the second thing that is very different between the US and Australia is the confidentiality of the jury deliberations. So in Victoria, a juror is not allowed to tell anyone, and certainly not allowed to publish anything that was discussed in the deliberation room, anything that was argued or voted upon, or that led them to their verdict. Whereas in the States, you can be on a jury, deliver a verdict, and then write a book. Go on CNN and get interviewed. And as I said to Jane last week, Oprah Winfrey was on a jury and did a whole show about her juror experience with the other 11 jurors on stage. So very, very big difference. So let me very quickly tell you how those 40 people got there. We have about 500 jury trials a year. So there's 500 of those times 40 people that go into courtrooms every day of the year. working backwards or starting from the beginning, they are randomly selected from the electoral roll. So if you are on the electoral roll, and you must be on the electoral roll in Victoria with compulsory voting, you may be randomly selected. And every couple of months, we will randomly select 5, 10, 15,000 people from the electoral roll. Right now, as we speak, over the next 6 days, we will be randomly selecting 70,000 people for jury service starting next year. So for trials that are expected to start in January of next year, across all of Victoria, we've just lodged those random selection notices of selection with Australia Post. That notice of selection comes with a questionnaire, and we urge you to jump online and answer the questionnaire. And basically our role is to assess your eligibility as a citizen, because some people may not be eligible for jury service, some people may be disqualified from jury service, and many people will have a very good reason as to why they can't do jury service. So of the 200,000 notices of selection that we send out every year, 2/3 of the people fall away at that stage. They will never get a summons because they've told us a little bit about themselves, and we've assessed them as being ineligible, as in the last 10 years, have you been a judge? Judge Patrick puts up her hand and says, yes, I was, tick, you're ineligible. In the last 2 years, have you been before a court and sentenced to anything? If you say yes, well, you say you're not disqualified, but somebody who answers yes to that question is disqualified. Just means they're disqualified and ineligible on this occasion. We get them off the books, and they may be randomly selected again when the answer to that question might be different. We might randomly select Judge Patrick in 12 years and the 10 years is up. Although if you've been admitted to practice in law, you're out forever. So you got the double whammy. So disqualification is around mainly, well, almost exclusively the possibility of past criminal activity and bankruptcy. Ineligibility mainly against your occupation. Are you in any one of these occupations that would make you ineligible? But then excuse for good reason, and that's the third bunch. That's where we almost feel like we are one-to-one relationship with 200,000 citizens in Victoria, whereas people can tell us a little bit about themselves and they may want to be excused, such as I'm self-employed. Therefore, if I do jury service, I'm going to lose money. Okay, that's fine. Because if you're not self-employed, your employer is obliged to make up your pay, so you don't lose money. Or I take care of children during business hours, or I'm sick, or any number of excuses. So from the people that are eligible, not disqualified, and available, from that 200,000, we're left with, quite honestly, about 70,000. From them, we will summons people to attend on the day to be part of the panel in Judge Patrick's trial. That it also gives the person an opportunity to apply to be excused or deferred again. And if I can, human nature is a funny thing. Randomly selected, you probably answer the questionnaire quickly, send it in and say all's good. 2 or 3 months later, you get a summons and the rubber's about to hit the road and you think, oh, these guys are serious. And I suddenly remember that I have a very good reason to be excused. And so you can apply to be excused. So of the 70,000 people we summons, only about 25,000 people actually attend. Again, about 2/3 fall away. Or we don't need them, through the court listings, and we might cancel the summons. So our summonses, as I just said, are informed by court listings. We're sort of the tail of the dog. And so when the courts, and we do a lot of work with courts to get an understanding of what their listings are, but basically we're trying to land, that group of people in the court building on time for judges when they're starting trials. So people will attend, and the number of people who attend the court building are dependent upon the number of trials that are starting. So some days there might only be one trial starting, and we'll bring in 45, 50 people. Other days there might be 6 or 8 or 10 trials starting, and we'll bring in 200 or 300 people in. And from that pool of people, randomly select smaller groups to go into the courtroom. We provide an orientation to give people a bit of an understanding of what they're going to experience in the courtroom. And because of COVID, we've pushed that orientation online, so people will know a week before they come in what they're going to experience. We then, we just get notice from the judge. We're ready, but we know they're ready to go because we've been talking with the judge's chambers with staff for the last weeks and days. And we then start the day. We've got a couple of hundred people in the pool room. We stand up and we don't say Judge Patrick, but we will stand up in front of the court, in front of the pool, and say we are about to ballot a panel of people for a criminal trial that is in the county court that's expected to go 7 days. And we ballot them, those 40, and they go up into the courtroom, and voila. Judge Patrick now has 40 people in her courtroom, ready, willing, and able to do jury service. And I will close by just saying our job, the only measure as to whether we're doing a good job or not, is how many excuse applications Judge Patrick hears once she starts that arraignment and jury selection process. So I have to be able to eyeball judges and say, you're not going to get people who are applying to be excused in your courtroom because they got a plane ticket to New York in 2 days, or a hip replacement operation in 3 days, or they're self-employed, or they care for children, or whatever. Our job is to deliver a group of people who are available and who are clearly eligible and been assessed as eligible. So
all right,
back.
That's how they got there. I'll be very quick. Sometimes one of the things that we do in the jury empanelment process is tell the jury about how long the trial is going to take and what the trial is about. And people do apply to be excused, sometimes because by the time it gets to that point, our trial estimate as to how long it's going to take is different than what the jury's commission has been told. So sometimes people do have a ticket for New York in 10 days' time, and we now say, look, this trial could go for 12 days. We didn't think it would, but now it would. The other thing that sometimes happens, of course, is that people ask to be excused because of the subject matter of the trial. So until they get there, they don't know what it's about. When the accused is arraigned, when the charges are put to the accused and the accused pleads not guilty, that's when they find out what the trial's about. And often that's a reason for applying to be excused. For example, if it's a sex offence trial and someone feels that's too close to home because of their personal experiences and that they could not be unbiased, then they should apply to be excused, and that's what we tell them. Now, one of the other things there's a challenge process where people have to walk in front of the accused, and the accused used to have 6 challenges. Now I think it's 3. Is that right, Paul?
It is, yeah. And I was just going to say one other thing just on that information that the judge gives. Before that panel goes in the courtroom, we are intentionally agnostic. Like, we are intentionally vague about what the trial could be, whether it's a Supreme or County Court trial, whether it's a criminal or civil trial. But we will often get people summoned who say, I don't think it's appropriate that I serve on a trial because I'll know somebody in the trial. And can I give you an example? A judge of the county court's husband was summoned. He called. He said, "Look, I may know, I know people. I socialize through my wife with." The answer that everybody agreed was, "You're not ineligible for jury service based on that relationship, but should you find yourself in a courtroom where you know something about the trial participants," and the truth is, he said, "That's fine." And he actually went into 2 court panels. He went up the first and said, "Sorry, I got to declare my bias. I socialize with that person, I know that person, that person." He wasn't a lawyer, and but he did end up in the Supreme Court panel and was not selected, but just it was that everybody was sure that there was no conflict there. He was an accountant. It wasn't like he was coming in with any bias.
And I'm just going to quickly deal with one point.
Yeah.
So the internet. In the old days, we used to always tell juries that they weren't allowed, they have to make their decision, and we still do, they have to make their decision based on the evidence presented to them in court and on no other basis. And that they're not allowed to go and look up information about anything to do with the trial. In the olden days, this was fine because people wouldn't be bothered going to a library. Nowadays, because of the internet, people can and do look up things on the internet about the law or about the people involved in the trial or about the offences. They're told they're not to do it because it would be unfair, because that information wouldn't be in front of the judge or in front of the other legal representatives to make submissions. So every now and again it does happen, and every now and again a trial the jury has to be discharged because the foreperson says to the judge or to the judge's tip staff, someone looked up the internet and told us what they'd found. In that case, the whole trial stops and you have to start all over again. And this is quite a big issue, and it still keeps happening. And generally, juries are very good and obey what the judge says, but every now and again things go wrong. That's it. Thanks, Lynn.
That's fascinating. Thank you to you both. It's a remarkable insight into both the process and the history. But Paul, can I quickly pick up on Jane's comment? Do you tell jurors as they file in and they are impaneled that they can't have their phones?
Well, it's not that they can't have their phones, but that we certainly tell them that they can't use their phones or any other, a computer to. We say exactly what Jane just said, and Jane's got her hand up, so she might be able to answer this better. But
the tip staff takes their phones once they're on the jury panel. The tip staff takes their phones, and while they're part of the jury, they can get their phone at the end of the day to take home. But during the time of the trial and during the deliberations, they can't have their phones, and we have to make special arrangements if someone needs to know, if a kid's sick or something like that.
Yeah,
they're not allowed to have them.
Yeah, that's fascinating. I'm just going to knock over one quick question that's come in because I think you might be able to deal with this fairly quickly, Paul. If you're a law student, can you sit on a jury?
Yeah, you're not ineligible. The ineligibility around being a lawyer is that, it says Australian lawyers are ineligible. So, and the definition of an Australian lawyer is somebody who's been admitted to practice. And we have had law students who say, aren't I lucky that this is probably the last chance of my life that I'll be able to serve on a jury. So yes, they can. And we wouldn't know they're law students, right? They'll say I'm a full-time student.
Yeah.
Sometimes in the challenge process, we ask them what sort of student they are.
Yeah.
So then someone will say if they're a law student, challenge and get them on.
Aha. Okay. So it can come up, but you're not ineligible.
They're not ineligible.
In the first instance.
No.
Got it. Okay. And just one other question before we go to the bigger issues around, how COVID has affected the whole jury system and court trial system. A question that came through quite early on, which when you were talking about summary and indictable offences, Jane, what if you commit a lot of crimes at once? And I think the intent behind the question here is that some of them are summary and some of them are indictable. How do you get dealt with? Do you end up in the higher court or are you okay in the Magistrates Court?
If they're indictable offences that can be dealt with in the Magistrates Court and you consent, they can all be dealt with in the Magistrates Court. If the indictable offences are such, or you don't consent, that they're going to go to the county court, then the county court can then, once the matter gets dealt with, can deal with the summary offences as well.
Right.
So, for example, if you pleaded guilty to some summary offences but not guilty to an indictable offence that needed a jury trial, but you were found guilty, then the judge can sentence you in relation to all of the things. The county court judge can.
The question was actually commented on murder. So that would go straight to
that goes to the Supreme Court, yeah. And the same thing applies in the Supreme Court, that they could take those, they can take those offences into account and deal with them, because you don't want people having to go backwards and forwards for courts. So, but you have to have you'd have to plead guilty. If you want to have a contest on the summary things, that would have to be done in the magistrates court.
Okay, it gets complicated.
Yeah.
But
It's
let's go to the 2 years of complication that we are just beginning to emerge from, hopefully tonight and tomorrow. COVID. Paul, what has that done to jury trials?
In the first instance, it shut them down. So as of mid-March 2020, there were no new jury trials in Victoria anywhere, Supreme or County Court, Melbourne or Regional Victoria. At the time of that announcement that shut down back a year and a half ago, there were some jury trials running, and they saw their natural end. So, you know, they went to verdict, or yeah, they proceeded.
Yeah.
So we had no jury trials from March to November 2020. We resumed jury trials in a limited way from just before Christmas, the middle of November, in Melbourne to about Feb. We got a bit more ramped up in Melbourne until May of 2021, where we started then resuming in regional Victoria. But there's been a lot of, I mean, I don't have enough time to tell you all the things that had to be put in place to allow that to happen, including completely retrofitting courtrooms and court buildings to allow for social distancing and other things. And as each lockdown has occurred, and we, as you said, we're coming out of lockdown 6, if a new lockdown occurred, the trials that were running would continue. No new jury trials for like 5 days in February and whatever. So it's been a huge, and it's an issue that I think Jane, you could empathize with. It is what is keeping judges awake at night, is because of the backlog that has then just been created. So yeah,
that really struck me when you were talking about dropping 70,000 letters on Australia Post to your randomly selected potential jurors. That is that a response to the backlog, that you've got a huge number going up?
A bit, and it's also a bit, and again, it probably don't have the time to get into it, but our system, the system that Juries Victoria runs around notice of selection and summonsing, relies on people deferring. You know, like we have people, you know, who aren't available when we first select them, but they say I'm good in a couple of months. But what happened, what we discovered with COVID was, during lockdown, we emptied the tank. Like when we had to ramp back up, we had no notices. We had nobody in our system to actually assess. Draw on. So we are sending out more notices and more summonses. We have sent out more notices of selection and more summonses in the last 18 months. Well, let's say in the last year, for less jury trials than we have, you know, previously, because, you know, the system was sort of self-perpetuating it. It allowed us to continually roll people through. So it's a technical thing, but it's.
And I know that, and you've both got insight in this, but I know that one of the responses to COVID has been to permit judge-alone trials, where a judge would sit where there would ordinarily be a jury. Jane, what has happened there?
Paul found out some information. So there's been, that was a position until that law was sunsetted, so that that system finished being applicable in April this year. But so any applications that were made before that for a judge alone trial, then those things can continue. And there've been about 33 already, and there are about 18 in the pipeline. So, and what the situation is that, so then the judge, like when I was a magistrate, the judge would make the decision about the facts and the law. Normally, it's the judge who makes a decision about the law and tells the law to the jury makes a decision on the facts. But in these judge alone trials, the judge makes the decision about the law and the facts, and it's only done with the consent of the accused and the consent of the prosecution, as I understand. And the judge or the court also has to agree with it. So sometimes the applications are declined. But it seems to have been quite, at least it's got those trials through, because it means there's you don't have a jury to have the problems of social distancing and so forth.
And look, again, I'm going to get into the technical, but those changes to legislation included other changes that allowed us to manage pools virtually. So that it changed the definition of attending jury service to allow us to not bring in big pools, but to manage them virtually and only create panels virtually. And it also allowed us to reimburse. It actually allowed us to reimburse jurors for their travel for anything, use of personal car, parking, Ubers, taxis, but not public transport. So it was to encourage people to stay on public transport and give people a bit more comfort, the citizen comfort to say, here's some things that have been put in place to allow you to not to worry about everything other than
infected.
Yeah.
So some changes and some innovations at huge numbers of levels in this whole process in order to keep the wheels of justice turning. I know that we are right on time and we're going to have to wrap this, and I'm going to do the evil journo thing, Jane, and throw the biggest question of the lot at you with 30 seconds for you to answer, which is, do you think that media portrays bail and sentencing decisions unfairly?
Mostly not. By and large, the reporters are quite good. They do tend to sensationalize things. They pick the cases which are of public interest in the sense that they're, more interesting subject matter. Every now and again, you feel really annoyed because you feel like what you've said has been misrepresented. Or I had one case which the person pleaded guilty and I sentenced the person. I won't go into the details because we don't have time. But I got a whole article in the Age about what ridiculous judge would allow anybody to be found guilty of this particular offence. And I was a bit annoyed because it wasn't really my job.
Guilty.
Advised by a QC, I have to tell you, who's now a Supreme Court judge. So there you go. So they decided that they would rather plead guilty and take whatever I handed out, which was a community-based sentence, than go to a jury trial and potentially be found guilty of what would have been a rape charge. So I won't. Yes, it was a very strange case. But I thought, oh, well, but I kind of, thought, okay, that was fair enough. I tried to have an argument with another media organisation that called in a particular offence what I thought was incorrectly, but the editor said, no, they were going to stick with it. So didn't win in on that one. It was because the thrust of the article was that my sentence was too low for this particular kind of offence. And I said they'd wrongly categorised the offence, which technically they had. And technically the maximum penalties and things were different. But they weren't bothered about that because their headline looked better.
Yes, I think there is.
I won't tell you which one that was.
There is a tension between media and court reporting, and I think we should be eternally grateful for court reporters who know their stuff and who know the beat well, and they are worth their weight.
Yeah, the courts really, really, really appreciate what the media does to make the public aware of what goes on in the courts and so forth. It's very important, and we do try and assist.
You do indeed. I'm very aware of that, and transparency is a critical thing for everyone. We're going to have to wrap it there because we're already over time, but that was absolutely fascinating. Thank you so very much to both of you, former County Court Judge Jane Patrick and Victorian Juries Commissioner Paul Dorr. A pleasure as always. Thank you to everyone for being with us for this online Law Talks, and we look forward very much to seeing you again soon, whether it be on screen or in person. And go well. Thanks for being with us.
Thank you, Lynn. Goodbye. Thanks,
Lynn.
Paul.
Bye, everyone.